What can a probation officer not do? Probation officers in New York must follow legal limits and cannot create their own rules. A probation officer's primary job is to supervise people on probation, monitor compliance with court-ordered conditions, and connect them with rehabilitation programs while reporting violations to the judge. The court, not the officer, decides what conditions apply under Penal Law 65.10. Common conditions include checking in regularly, staying within the jurisdiction, working or attending school, participating in treatment, and paying fines. Probation officers cannot dictate your job, where you live, or relationships. They enforce the court's rules but do not have authority to add their own conditions. Only a judge can modify or add probation conditions, so if an officer tells you to attend a new program or move, you can verify it with the court or consult an attorney. Under Corporal 410.20, the court retains sole authority to modify probation conditions, making unauthorized demands unenforceable. New York's search and seizure rules allow probation officers to conduct searches only under specific circumstances. A court-issued search order under Corporal 410.50 may authorize a probation officer to search a person or property when there is reasonable cause to believe a violation occurred. If your probation terms include a standing consent to search condition, officers may search you or your home without a separate order, but searches must still be reasonable under the Fourth Amendment. Without a court-imposed search condition, officers need your consent or a search order to enter your home. Probation officers are not allowed to perform random warrantless searches, open drawers, or go through belongings during home visits unless authorized. They cannot seize property or demand money without lawful authority. Any seizure must be tied to a lawful search or enforcement action and comply with constitutional protections. Officers cannot require payment of fees that are not part of the court-ordered sentence. All financial obligations must be set by the judge under Penal Law 65.10. Probation officers cannot interfere in custody or family matters, dictate where your children live, or change visitation arrangements. Those issues belong to family courts. Misconduct by probation officers includes harassment, threats, unauthorized demands, physical or sexual abuse, or any behavior that exceeds their authority. If an officer imposes an unauthorized condition, conducts an illegal search, or retaliates against you, that may constitute an abuse of authority. Probationers have several rights under New York law to protect themselves. You have the right to report misconduct to the probation department or oversight agencies like the Office of Probation and Correctional Alternatives. You have the right to consult with a lawyer at any time during probation and during violation hearings. You have the right to a fair hearing under Corporal 410.70, where the prosecution must prove any alleged violation, and you may present evidence. You can petition the court to modify unreasonable conditions under Corporal 410.20 and appeal unfavorable decisions. Accountability measures exist for officers who overstep their authority. Probation officers who violate the law can face disciplinary action, suspension, termination, or even criminal charges such as official misconduct. Probationers harmed by misconduct may pursue civil remedies, including federal civil rights claims under 42 U.S.C. 1983. If a probation officer files a violation report based on an unauthorized condition, you can challenge it during a violation hearing. Your attorney can cross-examine the officer and argue for dismissal. Home visits must serve a legitimate supervisory purpose. Officers cannot use them to harass or intimidate you. Probation supervision is meant to help you stay law-abiding, not control your life beyond what the court ordered. Knowing the limits of a probation officer's authority helps you protect your rights and avoid unfair consequences. Many people consult a lawyer to understand probation rules and protect their interests. If you believe an officer has overstepped, speak with a criminal defense attorney who understands probation law and can advocate for you. Jason Bassett, Esq. is a Suffolk County attorney and former prosecutor who represents probationers and their families and can explain these boundaries. He has more than 2 decades of experience, is admitted to practice in state and federal courts in New York, and is involved in national criminal defense organizations. This law firm serves clients in Suffolk County, Nassau County, and surrounding Long Island communities, providing compassionate counsel and vigorous defense. The law firm is ready to help you navigate probation issues and protect your rights. Remember that a probation officer cannot impose new probation terms, conduct unauthorized searches, seize property, interfere with your family, or charge extra fees. Only the court can change your conditions. If you are facing an alleged violation or suspect misconduct, a qualified attorney can challenge the action and help protect your future. You can reach the law offices of Jason Bassett, PC at 631-259-6060 and visit the office at 320 Carleton Avenue number 4200, Central Islip, New York, 11722, United States.